Hi, everyone. It's nice to have an opportunity to talk to you again. And today we're going to talk about interprofessional healthcare policy and regulation. Now, over the last few weeks, we've had a couple of different topics per class, but this week it's a kind of heavy one. And it's just mercifully one chapter. I'm going to try to do my best to get through it in a way that is as engaging as possible. But there are a couple of moments where I think it's hard not to get stuck down in the weeds with some of the details. So bear with me, and I hope 20 to 30 minutes from now we've completed and we both have greater insight, or we all have greater insight into healthcare policy and regulation as it relates to interprofessional practice. So on we go. And I apologize, sorry. So we talked about this before, right at the beginning of the course. In chapter 1, we talked about it, that interprofessional practice became a huge priority between 10 and 15 years ago, and in particular around 2003, 2004, and even into 2005. There were several really important national meetings that took place. And in particular, we had these healthcare accords. And the healthcare accords were an opportunity where they brought all of the stakeholders together. Politicians were deeply involved in recognizing that given that in Canada we fund healthcare and we have provincial and federal regulation around healthcare, we need to have a real focus on what that healthcare is going to look like in terms of how it's funded and how it's delivered. And so as a result, there were some changes that happened in relation to healthcare funding that went from the provinces to from the federal government to the provinces and the territories. And the provinces and the territories had to commit to ensuring that at least 50% of their citizens, so 50% of the citizens of Ontario, 50% of the citizens of Manitoba, wherever it is, would have access to primary care. So that's primary care is often what we consider as first contact care. So your family doctor would provide primary care, or a family health team would provide primary health care, and that it should be through team-based practice. And so hopefully many of you experience that within your primary care experiences yourself, that it's a team-based practice. I know when I go to the doctor, there is a nurse practitioner who works in that practice. There is a physiotherapist. There is a acupuncturist. There's a range of specialists all working within a team, and that's the model that the provinces signed on to. And part of the reason that happened was that we had huge wait times across the country. Now, we still struggle with wait times, and some of you in your recent posts have talked about that when you were looking at a news article. So we still struggle with wait times, but they were really excessive. We also know that as we're trying to move care out of institutional settings, so out of the hospital and into the home, there's real gaps that we're experiencing. And that things like the affordability of equipment, medical kinds of equipment, and in particular pharmacare, so the medications that you require to keep you healthy, has really become exponentially expensive and difficult to finance. And the challenges in making sure that patients are receiving the right care in the right moment and that they have good access have been accentuated over the last several decades. And it was really important that the governments, both the federal government and the provincial governments, came together to recognize that how we can ensure quality of care in part is based on the idea that we regulate the role of various professionals. Now, for all of you I know as RPNs, I think I have a couple of collab students here, but most of you have lived with this for a long time, that idea that you're self-regulating, that there are responsibilities that you carry with that. And also we have privileges because of that. So it's not that other people tell us what to do. We regulate ourselves within our own profession. But that regulation comes because of legislation that really defines our scope and our rights and our responsibilities. And that structure really supports our ultimate goal of patient safety. And it's really important that as we're developing any kind of structure for healthcare regulation, we take into account our need to make sure that patients are taken care of well, and that we protect them from harm. But also, if harm occurs, there is an opportunity for patients to seek redress. So redress would mean I could make a complaint against you because I believe that the care you provide was inadequate, or I could sue someone if the care that was provided was not competent, things like that. And it's important that there be a structure in place to manage all of that, the expectations of care recipients and the responsibilities of healthcare providers, right? And it's important also to recognize that although this sounds fairly straightforward and simple in writing, in practice it's difficult, because as we regulate the role of various health professionals, we can either enhance healthcare, we can make it more possible for professionals to practice most effectively, or we can obstruct their care. And in particular, one of the things that we can obstruct or put a barrier towards is their ability to work together. So if we create this regulation, that means that patients can seek redress, should something negative happen, then healthcare providers often suggest that they have to practice autonomously, because if there's a potential, for example, that I'm going to be sued, I don't want to be working with someone else and responsible for what the actions that they take. That thinking is not accurate, but that thinking is quite common. So we'll talk about that a little bit more. So let's talk about regulation just a tiny bit more. And again, this is where we can easily get into the weeds, and I'm going to try very hard not to. So legal regulation for our professions, that broadly includes any law and that establishes the norms of behavior. So we know with the College of Nurses, there are established norms of behavior that are included within regulation of registered nurses, registered practical nurses, and RNEC nurse practitioners. And also within that regulation, there are the mechanisms that allow us to ensure that those regulations are enforced. So mechanisms by which you can be called in front of the College of Nurses to respond to a complaint, things like that. And within regulation, there are two branches that we look at. So two branches of law. So one is the law that refers to professional regulation. And within each profession, there is legislated self-regulation. So legislated self-regulation for nurses, legislated self-regulation for physicians, legislated self-regulation for respiratory therapists, right? You get that. There is also something called tort law. And I'm going to talk about that just a little bit more in this presentation, so hang with me. And in tort law, that's just what we call a common law. So that's law that occurs or is made through the courts. So each time a patient sues for something that was done erroneously, for example, and there is a decision, that decision becomes what's known as tort law. So that decision lays down the path for future lawsuits to either be heard and upheld or defeated. So tort law is law that continues to grow based on cases, right? Cases that happen. And again, we're going to just focus again on this professional regulation a little bit more, that all of us as professionals are regulated at the provincial level. And you know that because, for example, if you're an Ontario nurse and you want to go and practice in another province, you may have to go and write the registration exam, or you may have to show certain requirements are met. And part of that is the difficulty with that sometimes is because most of the provinces in Canada have a bachelor's degree BSCN entry to practice, whereas some still have a diploma entry to practice. So you may or may not have met those requirements, or you may have to show that you have met those requirements in different ways. So professional regulation falls under provincial regulation, provincial jurisdiction, but also the federal constitution, our Canadian Constitution, which entrenches that. And there are some really important processes that happen under this professional regulation. One thing, and I sort of alluded to that with nurses, is that it determines, under this regulation, it determines what are the educational criteria that have to be met in order for licensure or registration or certification, whatever it's called in that profession. So, for example, in Ontario, you must earn a BSCN or equivalent in order to be able to write the national registration exam. Applying those criteria also is essential in determining who is admissible to the profession. And again, I'll give an example from nursing. In nursing, it also says that you must be a person of good character. And that relates to, so often we refer to police checks, you have a criminal record, other kinds of things. One of the other core processes in professional regulation is that the structure of it is necessary in order to help the registrant ethically uphold their professional responsibilities. And so often that it requires that you have to take part in continuing professional development, so lifelong learning. And again, for us, with the College of Nurses, there are requirements that tell us that we have to engage in reflective practice, and we have to continue to upgrade ourselves. And then finally, there have to be mechanisms that deal with concerns about members, right? So those concerns could be around patient complaints, they could be concerns around your own competence or other things. But within the legislation, one of those core processes for each of the regulated professions is there has to be a mechanism by which the public can register concerns about the practice of a regulated professional. So there is this sort of legislative model that includes many of the provinces across the country, in which the healthcare providers like us are governed by common statutes and by legislation that applies only to a specific group. So for example, the example here, occupational therapists practice under the Regulated Health Professions Act and Occupational Therapy Act. And so for us, for nurses, we have the Regulated Health Professionals Act, and we also practice under our own act. There is also a traditional legislative model, and in the traditional legislative model, you don't have the common act, you only are governed by your own act. So for us, think in Ontario, we all, nurses, physicians, OTs, PTs, RTs, all of us work under the Regulated Health Professions Act. So that's an act for all regulated health professionals. And then we work under our own specific act. But in other provinces, they just have the traditional legislative model in which they only have the act that relates to each of the professionals. They don't have that common act like the Regulated Health Professions Act that we're used to. So why do we need regulatory processes? One, they're necessary for us to be self-regulatory. So to be able to monitor our own profession and determine the requirements under the law and how those requirements need to be met. And these regulatory systems are really essential in differentiating the various health professions and our independence. So the government doesn't tell us what to do specifically. We are entrusted through these legal processes to self-monitor and to determine appropriateness of actions and responses. So remember I talked to you about tort law. And do you remember that tort law is what is a law that is made case by case. As a case comes to a court, a judge or a jury make a decision, and they apply that finding to new cases that come forward. And those principles then become part of law. And tort law requires that healthcare providers work appropriately. So we follow appropriate procedures, we possess the necessary skill and knowledge to enact our role. And within tort law, so in tort law, that's where if I were to sue a healthcare provider, it would be under the conditions of tort law. And within tort law, the liability or the responsibility for payment of damages rests with the provider if they have to pay damages to the patient. So within these tort law cases, it allows the patient what we talked about a little bit earlier, redress. It's a mechanism for redress. It's a mechanism for correcting what went wrong. Now, let's say somebody dies. I think a family member would say, there's no way to correct that. A person has died, giving me money doesn't help or doesn't fix it, but it may help to offset the very negative consequences of that. And certainly when there's injury that may have life consequences, it is so very important that there be that mechanism for redress. We don't hear about it as much in Canada as we do in the United States, where Americans are often referred to as very litigious in relation to healthcare. But in Canada, it is also necessary that there be these mechanisms and that Canadian citizens and recipients of care have the opportunity to respond to those and to make use of those. So when you work in an interprofessional team, how does liability work? Now, that's an interesting question because that's one of the challenges in working within a team. So if we all work as a team and something goes wrong, who's responsible? Is it the whole team? Is it individual members? Is it the member who carries the most insurance? How does that work? Often, this is the reason that many physicians have used to say that interprofessional practice doesn't work and I need to maintain my own authority as head of the team because I'm the one who will be sued if things go wrong. It's actually not true, and we're going to talk about that in a second, but it for sure is a prevailing idea. When we think of other healthcare professionals, for example, ourselves as nurses, the pharmacists, the OT, the social worker, we have increased responsibility over the last 20 years in particular for decision making, and we're held to a standard of care expected of every other member of the team, including the doctor. But it's important to recognize that we're also asked, are we expected or held to a standard above that of our role? So that's the question that happens. So if we're all in this together, am I held to a standard not of an RN, but are we all held to the highest standard, to the standard of the highest level of care? Typically, that would be the doctor. And so the court system has responded to this in an interesting way when when healthcare teams have been sued and they make a determination about who is responsible for paying out that fine or that judgment. And so what they have found, which is, it's really interesting, is that the damages, all of the damages are recovered from whomever on the team has insurance. So regardless of who on the team is most or least responsible, whomever on the team has insurance is required to pay out, not just proportionally. If I'm 10% responsible or there were 10 people on the team, I don't pay 10% of the damages. The person is required to, the patient, the family, the person who sued should be getting their settlement, and that comes from whomever on the team has insurance. And as you know, for RNs now, we are required to carry our own liability, right? And that's part of this process of ensuring that all health professionals are part of supportive of mechanisms where there is this capacity for redress for patients and their families. So in moving to this new landscape where we are saying that all health professionals work within a team and that we are all self-regulatory and that as we work together, we all carry shared liability, it's really important that we deconstruct what that looks like in practice, in the reality of practice. And a couple of things were really helpful. One, the development of the Interdisciplinary Education for Collaborative Patient-Centered Care Practice, IEC PCP model. And that model really looked at not only where are there opportunities to be educated together and to practice together, but where does liability rest when you practice within a team. And also Leahy and Curry, these are the authors, they're lawyers and legal professors who contributed the chapter that you're reading to the book. And so again, I would say the chapter's a little bit dense because it's written by lawyers, because it is about legal stuff and we have to know this. But what they concluded from a very intensive review of regulation and legislation across the country was that this professional regulation and tort law, remember tort law is the case after case after case that's heard, a decision is made, and then we build law from that, that in both cases they support the development of interprofessional practice and that we can work very effectively in teams, and that our concern for litigation, our concern for lawsuits or responsibility when things go awry should not preclude that. And that really helps to validate that interprofessional practice does not have this artificial barrier around responsibility and liability. And so ultimately, what they suggest is that interprofessional practice can help to promote the evolution of professional regulation and tort law as that continues to move forward. So as we continue to hear new cases, we then can move forward in developing future law that further supports that regulation as it happens. So I'm going to take just a moment to talk a little bit more about Leahy and Curry's paper. Now, this is written more than a decade ago, but it's so really important. Because what they do is they sort of debunk, demystify some of this general prevailing concern, in particular held by medicine, about practicing within an interprofessional team. One, they said there really isn't evidence out there about in any way about how professional regulation hindered interprofessional practice. That's just not true. They also said that the three strengths of self-regulation, so knowledge of self-regulating bodies, credibility and influence of self-regulators who are within the profession, can actually ensure a level of independence from government and the managers of health, and that is so critical. If we are to have a healthcare system that allows Canadians to achieve the very best possible health care that is not governed strictly by government regulations, but rather by the decisions of healthcare teams, and that's so important. And then finally, that self-regulators can show leadership by collaborating together and replacing those old silos of traditional regulation by creating new models where we actually are regulated together. So not only do we learn together and we practice together, even more fundamentally at that very fundamental level, that we are actually regulated within the same regulatory body. So it's a fascinating new approach, and there's lots of opportunity for us to continue to explore that. We for sure have now made progress in that area, but this idea is one that has really piqued a lot of interest. They went on to say that there's no indication that the courts would actually say that liability is held by one member of the team versus other members, or impose a standard of care based on which provider should have been responsible rather than what was actually taking place. They also focused on that tort law again. And tort law really emphasizes clarity of your role. So do you know what you are supposed to be doing? Do you have, remember, the knowledge and the skill that we talked about a few minutes ago? And that clearly documented communication, the decisions that we're making, all of that can really help to ensure that teams operate efficiently. So rather than be afraid of tort law can really support us in developing the best possible teams, the best possible team structures and processes to enable us to practice effectively. And then finally, the use of expert witnesses to clarify. So in situations where things fall apart, when we look at what a healthcare profession's standard of practice should be and other things, it's really important that we bring in those expert witnesses who can ensure that we have a great understanding of what interprofessional practice looks like in court. So when you go into court and you have an expert nurse who testifies what nursing practice should look like, that's fantastic. But now we're talking about the interprofessional team. So do we also bring in an expert who talks not only about what a singular professional does, but what expert interprofessional practice looks like? And that helps to move us forward in terms of that transition to IPP. So in 2005, because of all of this, in 2005, the Canadian Medical Protective Association, and that is a representative of physicians in court, came forward and said how deeply important IPP was, how deeply important it was to the care of patients, to improving patient outcomes, and to promoting the best possible healthcare in Canada. They created a policy paper that addressed the fears that doctors held about their exposure to liability when they worked in a team, and also concluded that there is no justification for that. So when you're working within a team, the doctors felt that they would be the ones responsible, even though the whole team may be making decisions or other people may be taking leadership roles or other things, that ultimately the buck stops here with doctors. This position paper made it very clear that was not true. And that's really reassuring. But even though we have that in the position paper and it's very firmly stated, bringing that right down to the level of the medical professional who's being educated or a doctor in practice has been challenging. And it's interesting because ultimately the bottom line is that whether we have a physician-led team or we have a self-managed team in which the best person to lead in the moment is the person who is in that leadership role, should be made based on the circumstances. And the circumstances include whether there are clearly documented and agreed upon professional roles and responsibilities. Remember, tort law talked about that. We need to have clear roles and responsibilities and understanding, including an understanding of where does the patient play a role in all of this. And then also that idea that all team members must have their own liability insurance. And we do now, right? So for all of you as RPNs, you have it. For me as an RN, I have it. That's new. That is, it was voluntary before, and it is now the law. So what do we know about how all of this has unfolded to today? So since these accords in 2003, 2004, and then moving even into 2005, the goal was to increase access to primary care, and that has happened. For sure that has happened, but not enough. We really have, you know, the progress that we have made, in particular through the late first decade, toward the end of the first decade of the 2000s, was seeming to have moved us to a new place. But we see in the last several years a little bit of a stall out, and that's concerning. But here are some examples for sure. In Ontario, there are many, many more collaborative care models for primary care, and so we see that in the family health teams, family health networks, fantastic nurse practitioner-led clinics. And even when we look at Health Force Ontario, where there was a human health resources development process really to support that interprofessional practice. Another example is in Nova Scotia, where they have a collaborative care model that was developed, and this idea of a collaborative emergency center developed and trialed. Let's look at Ontario for a moment and really talk about this idea. Do you remember I mentioned it a few minutes ago? Instead of silos of regulation, can we move to a model where we have interprofessional regulation, where we are all regulated together? In 2006, so this is more than 10 years ago, the Health Professions Regulatory Advisory Council. So that's the advisory council that advises Ontario's regulatory bodies, concluded these things, and it's important to recognize that they concluded a while ago. The Regulated Health Professions Act, remember all of us operate under the Regulated Health Professions Act, it needs to be revised. And it needed to be revised for these reasons. One, if we wanted IPP to really happen, we needed a higher functioning system of regulation. So if we want IP to happen in practice, we need to make sure that that regulation of professionals together, that interprofessional regulation happens. Also, we needed to recognize that professional regulation couldn't really meet its mandate of protecting patients, right? So in our self-regulating mechanism, the goal of that is to protect patients. But we can't do that unless we recognize that interprofessional practice is a new reality of the healthcare landscape. So it is essential, as self-regulated professionals, we recognize interprofessional practice and we build that into our practice, but also on a broader level, we build it into regulation. And also this idea that interprofessional practice raises so many new questions about overlapping scope of practice, collaboration and standards of practice. So do we have standards of practice just for nurses, or do we have standards of practice, for example, around client-centered care that extend amongst the professionals? Issues of how do we deal with liability and liability insurance, and how do we manage patient complaints when it's a team complaint? So many new issues that are raised, as many other ones are sort of mulled over a period of time. The Health Professions Regulatory Advisory Council also recommended that changes needed to be implemented as part of legislation in Ontario, and that was really essential. That in Ontario we needed to make those changes, including making sure that interprofessional practice is a statutory object of all colleges. So the College of Nurses of Ontario, College of Physicians and Surgeons of Ontario, the College of Opticians of Ontario, all of those colleges must have interprofessional practice as an objective. And it's essential that those colleges, all of those colleges, including our own, work to foster collaborative practice among the members. So when we take this course and you think, oh, you know, I'm tired of this course, or I'm tired of learning about this, it is essential by the College of Nurses of Ontario that we find ways to make sure that we are educated fully about interprofessional practice and that we are effective in practicing interprofessionally. And also the second change that was recommended is that the scope of practice for professionals changes to allow professionals to work more autonomously and to the full scope of their knowledge and skills. And where I think we see that effectively, and you guys can probably give a much better example than me, is as we see RPNs have a much broader scope of practice, and that language and the real movement to see RPNs working to full scope of practice. Within Ontario, we also see that the Ministry of Health and Long-Term Care, which oversees the colleges, makes sure that they're fulfilling those responsibilities to collaborative practice. So we are at, so that it is mandated by the government, but it's also overseen by the government to ensure that this is happening. And so finally, I've just got a little bit of a checklist here. And it's a little bit of a video that talks about a very interesting book, and where we're looking in healthcare around teamwork and how different kinds of professionals can work together, and how we can create environments where different professionals can work together, not just as in terms of communication or in terms of practices, but in terms of regulation and how that works. So take a moment, watch the YouTube video. It really draws from aviation and what they learned about how it was necessary to practice together, and I hope you enjoy it. Thanks so much, and I will talk again soon, and I hope you all stay well and warm. And for those of you who have kids or who just need a break, I hope you enjoy the March break.